Case number 114897, 114898, State of Kansas v. David G. Lundberg.
Mr. Chief Justice, may it please the court, I'm requesting 3 minutes for rebuttal. And for the main part of the argument, we're going to divide it between my co-counsel, Mr. Kearns, and myself for 6 minutes apiece.
Before you start into your argument, will you please again announce your appearance for the record so that people who are watching you on the internet know who you are and who you represent?
And may it please the court, David Miller on behalf of David Lundberg, the appellee in this matter. This case is before the court today. It arose from the District Court of Sedgwick County, Kansas. The Securities Commissioner filed a 61-count complaint against Mr. Lundberg and Mr. Elzefan, alleging various violations of the Kansas Uniform Securities Act. Mr. Lundberg filed a motion to dismiss the majority of those counts. It ended up to be 49 of those counts. Based on the fact that Kansas lacked territorial jurisdiction over these alleged securities violations. We had a 2-day preliminary hearing before Judge Burgess in Sedgwick County. The parties filed a stipulation of facts based solely for the basis of the motion to dismiss based on jurisdictional grounds. And Judge Burgess subsequently granted the motion to dismiss. The Securities Commissioner appealed. The Court of Appeals reversed the decision of the District Court, and then this court subsequently granted the petition for review, both Mr. Lundberg and Mr. Elzefan. We submit that the Court of Appeals made several erroneous rulings below. The first one is the Court of Appeals held that the Uniform Securities Act should be broadly construed. Jurisdictionally speaking, should be broadly construed. And we submit and we argue below that while generally that is true, in the context of civil securities cases, this court has held that the Securities Act should be broadly construed because it's remedial in nature. However, in an older case from 1930, from this court, the Wigington case that we cited in our briefs indicated that and held generally that yes, when you're talking about setting aside the securities transaction itself in a civil case, it's remedial in nature. And it should be broadly construed, that is the act. But when you're talking about imposing a criminal penalty for an alleged security violation, which is in fact what we're dealing with here, then the Securities Act is to be construed strictly, as is normal in the normal criminal statutes.
Counselor, I don't want to interrupt because I know you've got several numbers, but
Sure.
I guess as a threshold question, I want to make sure there's no dispute, is there, that the promissory notes and the LLC memberships would qualify as securities under the Kansas statute?
We actually filed a motion in district court challenging the fact that those are securities, but that issue was never argued before the district court.
I mean, from your point of view, is it still hanging?
It is.
Okay.
It is.
I'm sorry.
Oh, that's fine.
But those promissory notes relate to property in Wichita, doesn't it?
That is correct.
And your clients spent some time in Wichita making the plans, going over the buildings. They actually were present much of the time during this time this investment opportunity was going on. Isn't that correct?
That is correct.
And the laws of the state of Kansas also apply to this investment opportunity in most instances, doesn't it?
Apply in which way?
Apply, if there's any contesting of the laws of the state of Kansas would apply to the investments. I think that's, and maybe Minnesota in some instances, but mostly Kansas. And I guess my question is, why isn't that a sufficient nexus for this?
Well,
For the Securities Commissioner's Office to proceed on criminal charges with those connections to Kansas and Kansas property and your clients being in Kansas. It seems to me that that's just as, regardless if it's a narrow construction or a broad construction, it seems to be a nexus here that would suffice.
and in response to your question, those activities that you just mentioned have never really ever been held to be a sufficient nexus, even in civil securities cases. And we're proceeding under the Securities Act has its own jurisdictional
Right.
statute, which is separate and different from obviously the general criminal jurisdictional statute. And the cases that we cited in our briefs, actually the treatises, fairly well-respected treatises that we've also cited in our briefs, Professor Long, they all say, and are pretty uniform, that the drafters of the Uniform Securities Act made a conscious decision to premise jurisdiction not on principal place of business, not on incorporation in a state, but upon the transaction itself. Where did the transaction occur? And the jurisdictional statute under the Securities Act specifically, we think, almost has a negative presumption, because it starts by saying the provisions of the act shall not apply unless, and then the unless is, was the offer made in this state? Was there acceptance either pointed to this state and accepted in the state? Those are the two jurisdictional hooks. So it's where the transaction occurred.
Even if we accept that we have to just rely on the statutory language and not some sort of vague nexus test, or whether any part of the sale took place in the state, those two tests that you argue should not be applied, the ones that the Court of Appeals relied upon. Even if we accept that, and we just get down to the one word really that your argument hinges on, originates, why would the activities in this case not qualify as originates is commonly understood? When the whole deal began, because there were properties in Kansas, they wanted to redevelop those properties, they fashioned these instruments, etc.
Well, and I guess the answer, Justice Breyer, is how do we interpret originates? Certainly,
Exactly.
in the
I think that's
context.
the whole case from your perspective. Is at this stage, I understand you have other defenses that you may pursue if you end up back in district court, et cetera. But for purposes of this argument today, it all comes down to originates for you, right?
That's correct. That's
Okay.
correct.
So that's where I'd like to focus your argument, and I want you to explain to me why originates doesn't mean what it kind of means in common understanding. Where did it all get started? That's what originates means.
Well, what I heard your argument, what the originate, it seems to me we have to decide what we're talking about originating. Whether the security originated in Kansas or whether the sale. Isn't that what you're arguing?
That is
And so we're talking about the sale originating.
The transaction.
Yes, the
I
transaction.
understand that's
So
you have to focus on the transaction.
So the question is still on the table, but explain how the motion wasn't started in Kansas with regard to the sale,
The sale, yeah.
or the offer to
Set
sell.
in motion.
Set in motion.
Sure. The district court below held that the offers were completely work product of two California corporations, Providence Ventures, Inc. and There's another one.
Doesn't matter, we know.
Two California corporations. While there may have been some information that was supplied by Mr. Lundberg, Mr. Elzafon, that made it into those offers, the testimony below was very clear, and the stipulation below was very clear. None of the offers came from, if you want to say, originated from Kansas.
When you view an offer narrowly as the thing that can be accepted that makes a deal, right?
Correct.
We need to view it that narrowly. But in fact, that information, as you just said, came from Kansas. The whole plan to have these people out there as agents for the LLCs, or maybe sub-agents for the agents that your client and Mr. Kern's client are. I mean, that whole thing still started in Kansas.
And just to be clear, if I said that the information came from Kansas, I should
Back that up a
clarify
little bit.
that, because
Some of it-
none
some
of
of it may
the
have.
information may have been about properties in Kansas, but
Originated in Minnesota.
yes, it originated in
There's
Minnesota.
no dispute about that.
There's no dispute. In fact,
Okay.
that's part of the
I'm
stipulation.
sorry if I misstated.
No, that's fine.
So, the idea still came from here, right? The whole setup was dependent upon Kansas.
Well, and are we going to criminalize ideas?
No.
I mean, how far back are we?
Your whole argument, if I can just clarify and make sure I understand it, first of all, it turns on originates. It all comes down to one word. And we have to view offer and acceptance and sale and offer of sale very technically and very specifically tied to the statutory language. We can't look at those in any broader way either. That's the essence of your argument, right?
Yes, and in the
Okay.
context of interpreting this statute in a criminal case,
You have to view it
we have to
narrowly.
view it narrowly and
Rule of
conserv-
lenity versus broad construction of a civil remedial measure.
That's correct.
And to
Okay.
be sure, to maybe say it another way, you were focused on the actual utterance, whether that be written or oral, of here is a security for you to purchase, and nothing broader than that in terms of what the offer constitutes.
And that's correct. And the evidence was very clear. All the offers were made in California by California corporations to California residents. There was never any connection to Kansas other than the LLCs were incorporated here, which
And your argument is those corporations were best efforts agents. In other words, they had no obligation to accept so many shares or whatever. They just made their best effort to sell what they could, and what they didn't sell, didn't sell.
that's correct. And Mr. Ticelli and the other individual, Martinson and Ticelli, both of them testified they were not agents of Mr. Lundberg. They were not agents of the Kansas corporations. They were their own corporation. They made their own offers. In fact, the offers in many instances says Providence Ventures Inc. presents, not Wichita 19 presents or another corporation that was here. It was always the California corporation.
But of course, whether they were agents is a matter of law, not a matter of fact necessarily.
Correct.
Yeah.
Correct.
So,
And-
I mean, it's fine that they testified that that was their understanding, but that really doesn't control.
Well, and even as a matter of law, because under the Kansas Act, a corporation, which the California corporations were the ones that made the offer, a corporation cannot be an agent.
Okay.
Specify for us where the Court of Appeals went wrong on their analysis then.
I think one, on the way that you construe the statute, we're submitting it should be strictly construed. Second, they relied upon what they called the Newsom test and the Lentz test. And in preparation for oral argument, I did a search. I could not find a single criminal state securities case that ever applied the Newsom or the Lentz test. Those have strictly been applied in a civil context, and we submit are not really apropos in the criminal context. However, even if you were to apply those tests, if you read the Newsom case, In Newsom, it was actually offers and sales were made from facilities in Oklahoma. And the court said clearly the offer originated from Oklahoma because it came from the defendant's Oklahoma facilities. So really, if you look at the facts, I think, of Newsom and the facts of Lentz, they would support our position, even though in the civil, those decisions were in the civil context. I think I've gone over my time. Unless you want me to continue?
Well, you have split your time with co-counsel, is that right? If you need 30 seconds to wrap up your position, since we've been peppering you with questions, I'll allow that.
Thank you, Your Honor. Those are the basis. We don't think the Newsom and the Lentz tests necessarily apply here. And as an argument that we made in our petition for review, the far-reaching interpretation of this statute that was made by the Court of Appeals potentially could run this statute afoul of the Commerce Clause, as we have asked. But we think for those reasons the Court of Appeals below erred, and we would respectfully ask the court to reverse the Court of Appeals and affirm the dismissal by the district court.
Just to make sure I understand again, your constitutional argument is Plan B. We don't need to reach it if we agree with you on Plan A.
You don't need to reach it.
Okay, thank you.
Any more questions? Thank you, counsel.
Thank you.
May it please the court. Kurt Kearns on behalf of Michael Elzafon, and I apologize. I was freaking out a little bit because I thought all of our time was blown by David, and so I was over there squirming, and I apologize. I didn't think.
I thought you made some noise.
Yeah, I was like, darn. But Chief Justice asked an interesting question: where did the Court of Appeals go wrong? And really, if you just take the amicus's brief and cut and paste it onto the Court of Appeals opinion, you'll see that that's exactly what they did. They just adopted the amicus brief and said this is the law. And by the way, there's these two prevalent tests, and they call them prevalent tests, and the state calls them prevalent tests, but there's not a single case out there that talks about these. One unpublished opinion you can't even find on Westlaw or Lexis. You have to look up to the Blue Sky Reporter to find it. It's never cited anywhere. So I don't know how that qualifies as some prevalent test. Certainly when there's no criminal case out there that talks about it. If the Court of Appeals is right, then we really don't need KSA 17A601 that says it does not apply unless a sale or offer to sale is made in Kansas. Because if we construe it broadly and liberally, then how does this do anything? If we interpret it, and what our argument is simply this: when lawyers get out, and when Judge Burgess got out the book and he read, well, did the offer occur in Kansas? No. Did the acceptance occur in Kansas? It didn't. Well, then we're done because there's a statute I can read right here that says so.
Well, it says originates.
Well,
That's
right,
different.
exactly.
That Justice Breyer pointed out. That's
Yeah.
different. Why doesn't it originate in Kansas when we talk about how your clients were in Kansas, the property's in Kansas? It has to do that. Kansas law applies to any dispute as it arises from this transaction. Why doesn't it originate in Kansas?
Judge Rosen, we could also ask the question: why doesn't it originate in Minnesota, where the two Minnesota guys were from?
It can.
Or
Specifically,
why didn't it?
there can be different places where these transactions either arise, or there's different jurisdictions that can hold your clients accountable for fraud.
And what we're looking at then is, did Judge Burgess, sitting there listening to all these facts, make the call that this did not originate in Kansas correctly, or was he arbitrary, or was there some bias about it? And what we know is he heard all of the evidence in the case and found this: it didn't originate in Kansas any more than it originated as Michael or David were strolling along the path in Nevada and having ideas on how to create investments. Where these originated from were these independent people out in California talking about how they can make a buck to California people.
Opportunities in Kansas.
Right? And I guess their question is, why can't California then?
How do these California agents get an idea about this if it didn't come from, stem from Kansas activities?
Right. I would agree with that. And how does Amway folks that have bases all over the world, not have their idea from the Amway basis in New York City? So does that mean every state gets an origination because, we got Amway everywhere and they all talk to each other and they all share ideas on how to make money?
Counsel,
Yes,
can I
I'm
interrupt you for 1 second? It sounded like you thought we should defer to Judge Burgess, but isn't this a question of law?
It is a question of law, but it's also, as I put in my brief, and the Court of Appeals kind of made mention of it. It's de novo review, but we also have to consider whether it was arbitrary and capricious by Judge Burgess. And I would
Isn't there
argue
a
that
factual component? You know, your colleague argued, well, these were corporations and here were the offering documents and they had the California Corporation's name on them. And I mean, it seems like there's a factual component to considering whether the offer originated here or elsewhere.
And I think the undisputed evidence, the only thing they talked about, the Court of Appeals talked about, and I tried to tell them at the oral argument then, hey, you're also hanging a little bit of your hat on the part of a fax coming from a hotel in Kansas. Well, the evidence at that hearing was Elzefon had zero to do with that fax. So I'd also point out that we can't really group jurisdiction to every person that ever worked for that Real Development Corporation either. The Court of Appeals basically said, oh yeah, there was a fax, and didn't point out that, by the way, Elzefon didn't have anything to do with it. And by the way, Tichelli testified that fax didn't have anything to do with his offer, that he changed it. So that's why Judge Burgess then said, listen, these offers came from California. They were accepted in California. California can certainly go prosecute these fellas if they need to. That's where all the victims are. It'll be a lot cheaper for everyone anyway. So why do we have this statute that says it does not apply if it doesn't apply? Really, with the ruling from the Court of Appeals should have just started with, this statute really doesn't mean what it says. And I would argue, yes.
Why would the reasoning in State versus Grissom not apply in this? If any part of the criminal enterprise has some connection to Kansas, why would it not have the same reasoning apply as did to Richard Grissom?
I'm well aware of the Grissom case, the murder case out of Kansas City, and there is no securities jurisdiction statute that more specifically, as it relates, I guess the easy question is, because they weren't considering KSA 1712A601, they were considering a different jurisdictional statute. And what we have here is, as it relates to securities, we have a separate territorial jurisdiction statute that says this: the offer or the acceptance has to take place in Kansas, or it doesn't apply to that person. Now, I get that they don't really like that, but the reality is the legislature can choose to say, okay, we don't like that. We should change this statute and get rid of it, or we should clarify it.
So bottom line, your answer to my colleague's question is that Grisham was applying a different jurisdictional
Statute.
provision.
Yes.
Okay.
And securities are special, if you will. We're dealing with, the blue sky issues. And also, Court of Appeals completely ignored the United States Supreme Court Morrison case. They didn't even mention it. They just kind of said, well, that is an interesting thing, but it really doesn't apply here.
It's applicable only by loose analogy, though, isn't it? Completely different statute, international law.
But the same underlying reasoning.
Okay. Analogy.
Yeah, and what they did was they took these two prevalent tests that aren't prevalent, that we can't find anywhere, and call them prevalent, and then say, well, these two fit. And I would argue that's not appropriate, and I want to, if we can, reserve
It seems like
rebuttal.
there's a logical disconnect, though, that with your argument, the corporations never make an offer to sell. Some way their securities get sold without them making any type of offer. It seems like you just truncate that final step. Is there something about the transfer of authority or the process of getting it from the corporation to even to those, I guess brokers or whatever term you were using for the people in California? Do we focus on any of that transaction at all? And I assume you would say that all happened in Minnesota, even if we did, but just theoretically, is there a point that we have to look at getting that security to the people who were brokering it in California?
Justice Luckett, I believe the Court of Appeals ruled that this whole thing can be satisfied and ruled upon and decided by just looking at the stipulation that the parties entered into. And what that stipulation doesn't talk about anywhere is that they're part of this offer began or originated or had some part of it in the state of Kansas. You won't find that in the stipulation. You also won't find it in the testimony of the record. So what we have to do is kind of imagine and then also talk about a fax that was sent not by my client, by somebody else, to then succumb him to jurisdiction on a Kansas securities case that has a specific statute that says it shouldn't apply to him unless they make some kind of showing, which Judge Burgess says that they didn't.
Counsel, is the partial answer to the question that the corporations in Kansas or the LLCs are the issuers,
That may
not
be
the sellers?
that may be one of the arguments that they're the issuer and not the seller, but that would be, you know.
But their principal still made a deal with these folks to sell on commission in California.
And
Do you, for purposes of today, not later on in the case, any position you might need to take, but for the purposes of today, do you dispute whether under agency law, not under the language of the statute, but under agency law, that these commission sellers in California were agents of the Kansas, or of the corporation, the Minnesota Corporation in Kansas LLCs?
I would argue that we shouldn't talk here in a criminal setting about civil jurisdiction and whether an agent can tie some person into their civil lawsuit, because here we're dealing with liberty. It's a whole different ballgame. But yet all the Court of Appeals did is take all these civil case laws and say, well, because the civil case law says this.
I tried to couch my question so that you wouldn't be worried about giving something up in your criminal case.
Right.
I'm just asked a general question about agency law.
I would argue,
maybe
you know
could say,
what,
I do
in
criminal.
the end, if everything goes right, everybody makes money. So to that extent, yes, they're agents.
Well, let's trying to go back to my colleague's question about the original offer. These California corporations can't sell securities that are held by someone that doesn't want to sell them.
True.
Can they? I mean,
No.
these California corporations couldn't have sold the promissory notes that were held by your client.
No,
That if your client didn't want to sell them.
they're
right.
not allowed to sell them against their will. No.
Well, and so at some point, your client had to manifest an agreement to part with ownership. And why isn't that an offer to sell? I mean, they had to offer to sell the documents. Now, maybe the actual seller may be deemed to be legally in California as you've tried to structure, but I think the question was, they have to be put on the market. And why is it by your client, and why isn't that a de facto offer? I think that's where we're.
I think if
get
they're
it.
selling trinkets
Right.
and everybody said, hey, I have trinkets for sale, and anybody in the world that wants to come sell my trinkets can do it. If that's all it takes to be a part of an offer, then really every state that sells the trinkets or buys the trinkets and makes misrepresentations or doesn't make misrepresentations, everybody then has jurisdiction over really everything if you take it to that limit. If we're talking about, if all it ever takes is having an item available for sale and that's good enough to make the offer, then everybody's got jurisdiction for everything. Thank you.
We took a lot of your time with our questions. Do you need 30 seconds to wrap up, or do you think you've made your points, counsel?
I would just wrap up by saying and asking the court to consider that these two prevalent tests aren't prevalent. This has never been addressed by any criminal court anywhere, so you'll be the first to make that decision. Secondly, if that was enough here, then there's no basis to have this statute. I get that they want to stretch it and tug it and try to make it bigger than what it really is and do this liberal construction. But when we're dealing with freedom, it's strict construction. When we're dealing with money, it's more liberal. And our Supreme Court said that since 1938. Thank you.
Do we have any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, excuse me, may it please the court, Chris Elsleger appearing on behalf of the state. The state obviously believes that the unanimous Court of Appeals below correctly decided this case, and that this court should affirm that decision.
Mr. Eisler,
Yes.
let's just jump right in. The case comes down to origination, according to your opponent, and the test for that. And they suggest that these prevalent tests have never been applied in criminal matter before. Do you have a criminal case to cite for us?
For these two tests, I do not. I read a whole lot of these cases. I don't recall if they were civil or criminal or whatever. I was focusing on the tests. I will say that when it comes to jurisdiction, this court has already held that the security statutes or remedial legislation should be liberally construed, and by analogy, as the court already brought up, this court has liberally construed jurisdictional statutes in the criminal context, in Grissom, in Baragi, in State v. James. So
Those are different statutes.
certainly, but
Yeah.
the point is not that is that the court will liberally construe jurisdiction, not strictly construe them in a criminal case, because the rule of lenity and strict construction applies to the statutes that define criminal acts and punishments. But this is a jurisdictional statute, so the state submits that it should be broadly construed as the courts have previously.
If California has a comparable statute, would they be able to prosecute the people in California?
Certainly, and
Because and if they had theirs that said originates, the offer originates. My problem with multiple origins, if you look at the definition, I just pulled up the definition, and it says have a specified beginning. And how can you have a specified beginning that begins in Minnesota, Kansas, California, wherever? That's counterintuitive to me. If you have its origin, then an origin is an origin. It's not a multifaceted concept to me. And so why don't we have to determine one origin for this sale rather than the security?
Because I think it's similar to the other criminal jurisdictional statutes in that where any part of the criminal act takes place, there can be jurisdiction. And the many courts that looked at this that I read over all said that the blue sky laws, that there is no problem, there's no conflict of laws issue, there's no jurisdictional issue with multiple sovereigns, multiple states being able to exercise jurisdiction over these people.
But any part is a concept that emanates from these other jurisdictional statutes. Do you have any case law that says, because the language is, quote, if the offer originates from within this state, unquote, right?
Yes.
And it doesn't say if any part of the offer. So do you have any case that says that applies that portion of the offer?
Well, I think when you look at the Newsom test, is the one that looks at any step of the selling process is part of the origination. It's not just the offer and acceptance and so on. But certainly, this is, I think, certainly a case of first impression in Kansas. With this set of facts, I think it is a case of first impression overall.
Counsel, you do agree with your opponent that Newsom involved offers actually transmitted from within Oklahoma, right? They were generated there and transmitted from there.
I believe I believe that's correct.
Yeah,
Yes.
so that, it is factually distinct even if you like the test.
Yes. But yeah, there's no case squarely on point with this one.
And couldn't you argue because of that language in Newsom is really dicta about any part of the test? I mean, that wasn't necessary for their holding because the offer had been made in Oklahoma?
Well, the court still articulated and applied that test, and it's been followed elsewhere. I think though that a very simple answer in this case is that the offer originates with the seller. Who's the seller in this case? It's the Kansas LLCs and the defendants. And the court has, from the questions that have already come out of the court, you've recognized that. This isn't a situation where these guys in Minnesota are dealing with people in California, and there's no real relationship with Kansas. They're operating Kansas LLCs in Kansas to renovate and sell and manage Kansas real estate and seek investors to invest in Kansas real estate. How is it that Kansas would not have jurisdiction over someone who does that to defraud other people? That just from a common sense standpoint, that doesn't make any sense.
So if a real estate broker in California sells spirit stock and they have part of their facilities in Kansas, then Kansas would have jurisdiction if there was a fraudulent transaction involved?
I think it would depend on the facts, but under the facts of this case, I think it's important to note that the guys out in California, they didn't actually sell anything. Once they got an interested party, they just referred them to the defendants, and then the defendants conducted the sale. So these are not stockbrokers selling on a stock exchange out in California. These were people that were essentially just passing through information that was provided to them by the defendants who are operating in Kansas.
Counsel, I have a question about that. You just represented that they just referred people to the defendants. I thought that the stipulation reflected only actual contact with the defendants in one instance.
Well, that was my understanding. And I would have to look back through the stipulation to find out exactly. But my understanding was that the people in California, once they found somebody that was interested, then put them in contact with the Real Development, whatever the company was named. And of course, the materials and information that those California people were using, I mean, they were provided by the defendants. I mean, they couldn't have got that information and wouldn't have been selling or advertising that information if they didn't get it from Kansas. That information originated in Kansas. So again, it's hard to imagine how there's not an origination in Kansas here. The entire locus of the transaction is Kansas. It's Kansas real estate, 4 Kansas LLCs. These guys came down from Minnesota and set up these LLCs for the purpose of revitalizing and selling this property and getting investments in this Kansas property. So, I mean, clearly there's a Kansas connection. If you look at the Lentz test, I mean, certainly there's a clear territorial nexus with Kansas, and I think the Court of Appeals got it right. I mean, there's no sensible reason why Kansas wouldn't be able to prosecute crooks who are ripping people off from a base of operations in Kansas, especially when they're using Kansas property as the hook to get people to invest.
Counsel, one of the problems I'm having with the Court of Appeals decision emanates from the statute, subsection C, in the origination clause. Okay, you would agree, wouldn't you, that the origination clause in that statute applies only to offers, correct?
It says offers in this state, right?
Okay, then why does the Court of Appeals on page 731 of the opinion say that a sale or offer to sell a security originates in Kansas if any portion of the selling process has occurred here? How do we associate selling with origination when the statute doesn't? Does that make sense?
Yeah, I understand. That stems from the interpretations of these uniform statutes that have been given by other courts. The Court of Appeals looked to those other courts and how they've interpreted the same language and followed that. The reason being is that these blue sky laws, all the courts that looked at, said they were supposed to be liberally construed to the broadest extent necessary. The Seventh Circuit in Green said that the definition of sale is itself liberal. Its obvious purpose is to exclude nothing that could possibly be regarded as a sale. And the purpose is the intent behind this was to, this court said in Reinauer, was to place the traffic of promoting and dealing in speculative securities under rigid governmental regulation and control to protect investors and to prevent, to the extent possible, the sale of fraudulent or worthless speculative securities. So the Court of Appeals was following legislative intent
and was simply following the same type of interpretation that other courts have used in interpreting this language broadly. So it's more than simply just the standard contract law offer acceptance and consideration. It's and I think it goes back to the Newsom test, and every part of the selling process is part of the offer. And so,
But the origination clause in this statute only applies to the offer and not the sale, right?
well,
Seems
yeah.
like that's a limit. That's a provision that I've got to interpret as being limiting.
Okay, if that's certainly your prerogative to interpret it that way. You're right. I mean, subsection A says sales and offers to sell, but subsection C says offers in this state. And so I see your point.
I don't care if it's my prerogative. The question is, do you think it's wrong? And if it's wrong, tell me that it's wrong.
Well, I would fall back on the Newsom test and the way the other courts have liberally construed the similar language. This is a uniform statute. They've construed that terminology to be broader than just the narrow confines of an offer.
The only other thing that's been bugging me about this is we can't decide this case on a categorical basis. We have to, and by that I mean we have to look at each count. You have to meet these elements for each of your 51 counts, or however many counts there are. 61
A lot of counts.
Yeah, but it's a count by count consideration, correct? If you get them on one count, you don't get to drag in the other counts. Each count has to stand on its own, correct?
I believe that would be accurate. Yes.
Well, we have some remaining counts, right?
They got dismissed, didn't they?
Yeah, the remaining counts were dismissed, so the state could appeal.
But not on this basis. That was a voluntary.
Yeah, voluntary dismissal. Yes,
Yeah, legally, there were what, 5 counts that remain.
I believe so.
They
And
all
that-
had to do with the Kansas buyer, right?
Yes. I know.
The issue before us today is strictly territorial jurisdiction.
Yes.
So even if, at some point in the future of this case, the district court's gonna have to pick through each count, today, we just need to decide whether there's territorial jurisdiction generally, right?
I would agree with that, and
Okay.
the point that I wanted to bring up in looking at the language of the statute is I think it's important to note that when it says offers in this state, it says for the purposes of this section, an offer to sell or to purchase a security is made in this state, whether or not either party is then present in the state. And I think that's important because that shows the statute contemplates some extraterritorial application.
As long as you've got origination.
And I believe the origination originates with those Kansas LLCs and the Kansas property.
You're arguing a general common understanding of originating.
Yes.
Yeah.
But back to Justice Biles' question, the act itself has separate definitions for sale and offer to sell. The sale includes every contract to sell, contract to sell, disposition, security or interest in security for value. Those would seem to encompass every aspect of the process. But there's a separate definition for offer to sell in the act, and if offer to sell was intended to include all aspects of the sale, why did they have two definitions, separate definitions in the act? Do you understand what I'm
I
trying to
understand what you're
Yeah.
saying, and I'm going to encourage the court to find that the sale definition is the more encompassing, since it includes offer to sell, is the appropriate one to apply here. I presume that the legislature did that for imagine different circumstances where it would be important. But as I stand here at the podium, just trying to think off the top of my head, I can't give you an example. I've got the definition of sale right in front of me, and I think that's the appropriate definition to apply here.
A California agent could sell interest in a non-existent Kansas corporation. It wouldn't originate anywhere but in California, would it?
Well, in that case, your hypothetical, I think that's correct. If it's non-existent, if the California person just dreamed it up, then there would be no Kansas connection, there would be no origination in Kansas, then yes, then jurisdiction would apply.
So there can be,
But certainly here,
a sale can be illegal and an offer to sell can be illegal under the act
yes,
separately.
I believe so, yes. Yeah. If there are no further questions, I'm sorry.
No, I think you and I are sharing the same thought. Do you have any further presentation?
No, I would simply reiterate that we believe that the Court of Appeal was correct. It was a unanimous decision that is consistent with the prevalent tests, and ask this court to affirm.
Do we have any more questions? Thank you, counsel.
I wanted to address, Justice Johnson, your question about can some portion of an offer, is that sufficient? And I would note on page 19 of our brief in the Court of Appeals, again, it's a civil case, but it's McCullough. And there they say, even though there was some information or some correspondence that came from Oklahoma in that case, that was not the offer that was ultimately made in that case. And they said simply because some information or some correspondence that may have come from California, not amounting to an offer, is insufficient under the Oklahoma Act, which has adopted the Uniform Act, as Kansas has.
Where did the offer from these corporations come from to the, however we're going to talk about the agents in California? Did that happen did any of those acts happen in Kansas? Did any of the communications between the defendants and the California people happen in Kansas under the stipulation?
There was, based on the stipulation, there was a fax.
That fax.
That was sent.
And that's it.
As far, yes, based on the stipulation. And just to be clear, that fax, that was just talk between two.
So any other recruitment or information about we have these promissory notes available for sale or whatever, that happened either in California at that one meeting or while the defendants were in Minnesota?
That is correct.
You're talking about the handwritten, that's the fax?
Yes.
And then we've got a subsequent exhibit to the stipulation that types it out, right?
I'm sorry, maybe
It was S14 and 15, is that right?
that's correct.
Okay, thanks, I just want to make sure I knew what you were talking about.
And that fax, though, Ticelli testified that fax was not what he offered to the individuals in California. In fact, the interest rate changed, the payouts changed, and he changed them himself to benefit the people that he was selling to in California. So the idea that somehow he's acting as an agent of Mr. Lundberg, I think would be contradicted by that fact. And just to correct, just briefly to correct something I think the state argued, these sales occurred in California. They all occurred in California. The offer, there was no reference back to Mr. Lundberg or Mr. Elzefant. The offers were made in California. They were accepted in California. The money that was involved in the sale were wired to bank accounts in Minnesota. So no part of this transaction occurred in Kansas.
The closest thing we have is the signature on the promissory note to Belter, right? Sold to Belter.
That is correct.
That was signed in Wichita?
It was signed in Wichita, but the complaint that charges that says that the sale occurred on February 2nd, and not that the promissory note was signed on February the 28th. And I see my time has expired. I just wanted to mention we did attach a letter from the Securities Commissioner, a special investigator in December of 2012, in reference to a count in his complaint, Mr. Piper. And at that point, in December of 2012, the Securities Commission said, Kansas doesn't have jurisdiction. But yet now that is one of the counts that is charged in this complaint. We would ask the court to reverse the decision of the Court of Appeals and affirm the dismissal of the counts.
Any more questions? Thank you, counsel. We thank all three counsel for your arguments this morning. The court will take this matter under advisement.